This video today, I'll try and keep it very crisp, very short, probably under 2 minutes. And in these 2 minutes, you will understand something very valuable relating to what is negligence when you visit a hospital and what does the law say about it. This is going to be very interesting and necessary for final year law students who have chosen law and medicine as a subject. It is also interesting for people who are presently in the hospital or have somebody in the hospital. It is also essential for doctors to understand the correlation between negligence and law. Negligence as a theory is a very ancient theory in law. Professor Salmond, way back, probably in the 1800s, I don't remember the era, defined this very thoroughly. It has also been defined by Jolovich, and I am going to probably scroll down here a very, very fine definition by somebody called Anderson in the year 1856 in a case Blythe versus some particular water company. That will scroll down here, and Anderson defined negligence thus: omission to do something that a prudent man would do, or doing something which a prudent man would not do. So in other words, in layman's language, doing something which was not supposed to have been done, or not doing something which was supposed to have been done. So incidents where you hear those gruesome tales where an instrument was left behind in the body after surgery, that is doing something which a prudent man would not have done, and therefore negligence. Or probably not administering the right dosage of anesthesia or the right medicines before performing whatever medical procedure was supposed to be done, was not done. So that is the definition of negligence, and if it is proved that a doctor acted negligently, then the law comes into force, and the legal sections that can be fastened upon this doctor are as follows. They will all scroll down now. Very vast collection of sections, therefore doctors must probably take extraordinary precaution before they go ahead and treat patients. I am just scrolling down this quickly. Section 52, 80, 81, 83, 88, 90, 91, 92, 304A, 337 and 338 contain provisions that can come into play. If you're somebody who's dealing with the hospitals, if you're going through an unfortunate episode of medical problems, then probably it's good enough for you to understand one more provision. The doctor has to take what we call informed consent, within inverted commas. Let this be scrolled down now. Informed consent. Whatever a doctor is going to do, it's best that he informs the patient, takes his or her consent. This is one of the finest ways of avoiding a charge of negligence later on. It cannot be presumed that the patient knows everything. It is necessary that the doctor presumes that the patient does not know everything and takes requisite consent from the patient as well as his family, preferably in writing. Negligence for law students and for brother and sister lawyers, those provisions will scroll down now. They've already scrolled down now, but it's an interesting subject and holds prime importance. In fact, the inflection point or the meeting point between law and medicine usually is the subject of negligence. Thank you for watching this video. I'll endeavor to bring you more such videos. Thank you for subscribing.